The courtroom is a special place in American life. It is a symbol of the American ideals of justice for all and fairness in our society. But courtrooms are just places. They don't provide justice. People do that. Every day in courtrooms across Illinois, people are involved in the essential task of making the American justice system work. Decisions made here affect the rights, property, and even lives of our fellow citizens.
Good morning, ladies and gentlemen. You have been called to this courtroom this morning for jury service. And since many of you have probably not served on a jury before, I would like to tell you a little bit about our jury system, your duties as jurors, and about the function of the jury in the overall court system. The United States of America is one of the few nations in the world that employs the jury system. We adopted the use of juries from the common law of England, and there has been little change since our nation's birth. Trial by jury is one of the fundamental foundations of our country's great heritage, and it is jealously guarded by the courts in our judicial process.
The right to a trial by jury is guaranteed by the United States Constitution and the Illinois Constitution. This is the right to have the facts and the controversy of a case determined by the unanimous verdict of impartial jurors acting under my direction as judge. As a juror, you are a very important person in the courtroom, equally as important as the judge and as the lawyers. Perhaps for some of you, this is the first opportunity to be in a court for any reason. You may have come today with some degree of apprehension. Let me first speak to that. The courtroom is not a place to fear. You should enter in confidence, confident that everyone involved will receive full and complete justice. Now, let me describe the initial step in the trial process: the selection of the jury. Prospective jurors in a trial will normally be questioned in groups of 4 in the jury box. The answers to the questions will enable the court and the lawyers to determine which jurors to select. It may seem to you that some of the questions are personal, but there is no attempt to embarrass any juror. You may be asked whether you have a personal interest in the outcome of the case, whether you have a preconceived opinion about the case, whether you know the attorneys or the parties, or you have knowledge of the facts of this case. Each attorney may excuse a certain number of prospective jurors without giving reasons. Others may be excused for stated reasons of cause. You should not be offended if you are excused from sitting as a juror. That happens in nearly every trial across America.
Once selected to sit as a juror, you will be asked to rise and swear under oath to try the case before you and render a true verdict on the basis of the law and the evidence presented to you during the trial. Your duty as a juror is to listen to the judge, the lawyers, and the witnesses, to deliberate calmly and fairly, and to decide intelligently and justly. A few words of suggestion if you are selected to sit on the jury. The law and its procedures may seem complicated, but it is all based on common sense principles under the law. As a juror, use your common sense, and you will be asked to apply your common sense to the evidence and the law as presented in court. All of the evidence and the law that you will need to make a decision will be presented to you during the trial. You should not look to private sources of information, and neither sympathy nor prejudice has any place in this courtroom, only the evidence and the law. During your service on a jury, you should not talk to any of the parties, witnesses, or attorneys about anything. You should not even talk with other jurors about the case until you have heard the complete case and have received the instructions from the judge. In rare cases, a jury may be sequestered, which means that the jurors will remain together outside of contact with others until the trial and the jury deliberations are over. Usually, however, the jury is not sequestered, but jurors will be cautioned against talking with family members or with anyone else about the case. Jurors should also avoid news accounts of the case from newspapers, radio, television, and the internet. After you are released from jury duty, you may, but you are not obligated to talk with anyone you wish to about the case.
Now I would like to describe for you the 4 basic steps involved in the actual presentation of the trial. A criminal or civil trial usually starts with opening statements made by the attorneys. In a criminal case, by the prosecutor; in a civil case, by the plaintiff's attorney; and then in either case, by the defense attorney. Ladies and gentlemen, the opening statements are not evidence, but are intended to show what each side believes the evidence and the proofs in the case will show. Opening statements will give the jury a general outline or overview of the case in its entirety and will explain to the jury why the 2 sides are in disagreement. Following the presentation of opening statements, you will hear the presentation of evidence. This is by far the longest step in the case. Evidence will be presented to you through the presentation of sworn testimony of witnesses and the admission of exhibits such as documents, writings, contracts, photographs, maps, diagrams, things of that nature. Rules of evidence govern how and what will be presented during the trial. The judge actually decides on questions of the rules of evidence. For example, if an attorney makes an objection at some stage of the trial and the judge sustains that objection, you should disregard the question and any proposed answer. Of course, if the judge overrules the objection, you will hear the question and answer. Since you must base your verdict on the evidence, it is important that you hear all of the evidence. If, for example, you miss a question and answer that a witness gives, signal the judge in some fashion, and you will be given that information again, either through the court reporter or again through the witness.
After all the evidence has been presented, the next step of the trial is closing arguments. As with the opening statements, the closing arguments are not evidence. They are the summaries and comments by the attorneys of what they believe the evidence has proven and why the jury should decide one way or another. The final step of the trial is between the judge and the jury. The judge decides what law applies to the case. The jury is the judge of the facts of the case. The judge will read the jury the law that applies to the case. Jurors should pay close attention to these instructions because it is their sworn duty to follow them in applying the law to the evidence in deciding the case. Also, a written set of instructions of law will be given to the jury for its deliberations.
After the instructions, the jury has now heard the complete case in terms of the evidence and the law. The jury will retire to the jury room to deliberate the case and to reach a verdict. The first task will be to elect a foreperson to preside over the discussions in a free and orderly fashion. To reach a verdict, all jurors must agree on the outcome of the case. In this process, there normally will be differences of opinion among the jurors that will require discussion among the jurors. During deliberations, please remember to keep an open mind as others speak. Consider the opinions of fellow jurors as they should consider yours. In the end, after full discussion of the case, the jury will reach its verdict based upon the evidence and the law. Once a verdict is reached, the jury returns to the courtroom to present its verdict and to be discharged with thanks by the judge.
Ladies and gentlemen, we in the court system are aware that service on a jury brings with it inconvenience. We in the court system, judges, lawyers, the courthouse is our workplace, but for you, you are taken away from your businesses, your occupations, your personal obligations, and you are making a sacrifice. But I suggest to you that this is a small price to pay in serving as a juror, as a citizen of the United States of America. Those of you who have never before served as a juror will find your jury experience informative, challenging, and accomplishing. At the completion of your jury service, I submit that you will have a greater appreciation for the jury system and for our American way of achieving justice. Thank you.
Jury duty is a vital obligation of citizenship. It is an extremely important duty because it ensures that the greatest ideal of American society, justice, is fulfilled. For some people, the clerks, bailiffs, judges, lawyers, and other court personnel, it is their job to be in court. For jurors and witnesses, it's their duty to report when summoned. Jury service is sometimes tedious and can interrupt the routine of our lives. But put yourself in the place of the parties in the trial, whether it is a civil or criminal matter. For them, the jury is deciding issues of great importance. The jury is at the center of the American justice system, distinguishing our courts from so many other countries that have secret trials or even no trials at all. Justice is not automatic. We all have to work to make it happen.